Hello, it's Philip Taylor speaking from Richmond Green Chambers. I'm looking at a book today from Informa, which is in the Construction Practice series, and it's called Remedies in Construction Law. That's the book there. You can see what it looks like. It's a standard book. There's the contents, some useful cases, a great deal of information in footnotes, and the paragraphing at the side, which is very helpful, and at the back there's a very detailed index. It's about 400 pages long. It's an excellent book for anybody involved, as I am, in the construction bar itself, with some of the multi-track cases. This is a review which we've written on Flickr and given it the title Making a Suitable Case for Remedies, and this is what I'm basically putting forward. My wife Elizabeth and I have looked at this together, and we've come up with this review and said the book is seriously needed by the construction bar. The authors, who are a father and daughter team, Roger and Camilla Haar, have produced an essential statement of practice for both the academic and the practical elements of what we need to tell the clients in a construction case. In other words, what can I get? It's especially relevant in our view where we're negotiating a settlement which can crop up, and quite frequently does, in this specialised area of law, especially in part-heard hearings, often where the evidence has gone in a particular way. The case citations, I think, are really very good indeed. There's a detailed index, and the academic content and the commentaries from the other academic publications is really a very first-class effort. The book starts well with a description of what the construction bar does. It obviously covers building, engineering and technology projects. I'm not going to go into detail there because we obviously know what it does ourselves, but the book identifies the areas. So there are a number of books on the market covering the thorny issue of remedies for both tort and contract breach thereof, which really are so intermingled today in reality that you need a rigorous analysis to sort out what sort of remedies are required and therefore put the case to the court. So that's where Haar on remedies comes in. There are 25 chapters altogether, very detailed, lots of extracts. The one that I've found particularly helpful, as I say, is the last chapter on ADR itself, because it's the area that I'm beginning to find becomes much more important. That's it there. Becoming much more important, dealing with litigation, adjudication, mediation, and actually trying to resolve the dispute without having to go to court, put the wig on and address the judge. It may be that when there's a new edition, which there surely will be, we'll probably have an expanded version of ADR, which probably will be extremely helpful as we see the direction the courts are going in 2011 onwards with the cuts. So let me conclude by saying that the authors have made out a great case for handling the issue of remedies with an intelligent use of authorities, although, as they say, it's not designed to cover or include a whole range of problems in commercial construction projects, but it is there to give us an identification of the areas that are likely to be of interest when running a case, and that's just what they do. So Haar, as I call it, has an important place in the Chambers Library in both contract and tort sections. Thank you to Informa and the authors, and it's great to see a father and daughter team. Thank you. Bye-bye.